Well, good morning again, everybody. Good afternoon to you. And we're going to continue on now looking a bit more at the mediation process, which I think Sven's given us a very nice introduction and explanation of the role of the mediator. So we'll just be looking in a bit more detail about the whole process. Now, what I'm going to be describing here is what happens at the EUIPO Boards of Appeal in our mediation process. And as I mentioned yesterday, basically mediation is more or less free with us, or at least it's included in the appeal fee. So if you appeal a case to the Boards of Appeal, you have the option of mediation at no additional cost. However, it's a voluntary process, as I mentioned yesterday, and it can be available to represented or unrepresented parties. Now, we've discussed at some length that lawyers can actually be very useful for the process, and obviously, if a party is unrepresented, they are at somewhat of a disadvantage in the process. Nevertheless, it can happen that we do have unrepresented parties in the process, and there the mediator has to be very careful to try and redress the balance as best he can, but without compromising his neutrality in any way or impartiality. Now, how's the process initiated at the EUIPO? And basically, there are three ways that a mediation can start. So it can be that one party makes a request, or both parties make the request jointly, or that the rapporteur, that's, if you remember yesterday, I told you that at the Boards of Appeal, we take decisions as a panel of three, and the rapporteur is basically the reporting judge in the case. So the reporting judge can also propose the mediation process to the parties. And I insist again that it is just proposing. It always has to be accepted by the parties. Now, we're going to go into these three initiation methods in a little more detail in the next slides. So what do I mean by the unilateral request? Well, obviously it means that only one of the parties asks for the mediation. But of course, since it's voluntary and it has to be accepted by both parties, the next thing we need to do is send that request to the other party. So what we'll do is we'll put the case on hold before the Boards of Appeal. The appeal proceedings will be suspended, and we will transmit we will transmit the request to the other party, asking that party if he agrees to the mediation. We do that by a written communication, but now we have a system whereby we appoint what we call a reporting mediator, who's there to try and guide the party that receives this request about making an informed choice. So the reporting mediator will, shortly after the communication to the other party has been made, the reporting mediator will phone that party and introduce himself and try and guide the party towards making an informed decision on whether or not to agree to the mediation request that's been made by the other party. So, of course, if both parties accept, then the mediation process is triggered. But if one of the parties, if it says, "Well, I'm sorry, but I'm not interested in mediating this," then we have to leave it there, and the case goes back to the normal procedure of an appeal decision by the Boards of Appeal. Now, what about the bilateral request? Well, this is probably the easiest scenario. This is where a form is sent in. I showed you yesterday what that form looks like very, very briefly. And both parties would fill it in and they would send a request to the EUIPO Boards of Appeal ADR service saying, please, could we have a mediation? And then basically we would need certain details to be filled in on the form, and most importantly, they would need to choose a mediator. Sometimes it can happen that they have a bit of difficulty choosing the mediator. They see a lot of names on the list, and they ask help from the ADR service, the Alternative Dispute Resolution Service, in our Boards of Appeal, and then the staff, our administrative staff there, would try and help them in selecting an appropriate mediator, which could be on the basis of the language of the mediation or the experience of mediators for the particular problem in question, these sorts of things. And again, the proceedings will be suspended at the Boards of Appeal, so that the appeal proceedings will be suspended while the mediation is initiated and while it's ongoing until it's completed. Now, the third way that the mediation process can be initiated is where the rapporteur, that's the reporting judge in the Boards of Appeal, he or she will case manage the files. So when a reporting judge receives the case file, he or she will read through it, and there will be certain indicators in that in the file that could give the reporting judge to think, well, maybe mediation's a good idea. For example, if he sees that there are ongoing parallel proceedings anywhere else in the world or in the EU, or there are a whole load of cases coming up through the system in the EUIPO elsewhere, maybe there's an opposition, maybe there's a cancellation, then these would be the sorts of things that would be triggers in the mind of the reporting judge to propose a mediation. I mean, there are many more examples than that. If we have time, we'll go into that in a little bit more detail. But those are just some basic examples. And then again, the reporting judge would send a communication to both parties saying, I think this is a good case for mediation. Do you agree to it? While they're considering this, the case is put on hold. And as we saw in the first way of initiating the mediation, we would appoint a reporting mediator at the Alternative Dispute Resolution Service, who will liaise with the parties and try and guide them into making an informed decision on the case. I mean, as Sven mentioned in the last webinar, our first port of call, our first contact, is always with the lawyers. We cannot go directly to the end client unless that end client is unrepresented. And that means that the lawyer is the gatekeeper to the whole mediation process. If he or she is not persuaded that mediation is not in the best interest of his or her client, then that lawyer will be an obstacle to mediation rather than an ally to mediation. So it's very important that we give the lawyer all the necessary information to try and persuade him or her that mediation would be a good idea in this case and why it would be a good idea. Now, if it's accepted, then the mediation process will continue as if both parties had made the request jointly, because in this situation, both parties will have agreed to it. And in fact, they will then send in a request asking for mediation. If, on the other hand, one of the parties declines the mediation, then it's over before it even began. And we will go back to deciding the case in the usual way as an appeal decision. Now, how's the mediator selected? Well, on our website, there's a list of our EUIPO mediators, and you'll remember from what I told you yesterday that at our office, the mediation is done internally because we're not charging fees for this, and it's the only way that we can guarantee a costless service for the parties. And our bios or CVs, curriculum vitae, if you like, are on the website, and people can read through about what each of us has to offer in terms of language and experience, and make a selection. As I said, the ADR service can help if this is difficult. If the parties find this difficult to make their own selection, or they don't agree on who to select. Now, it's important for us to say that because we want to be flexible and because we want to help the parties as much as we can, it's always an option for the parties to go outside of the EUIPO. If they say to us, yes, we want to mediate, but we don't want you, we want the WIPO, for example, that's absolutely fine. We will not stand in their way. Quite the contrary, we will extend every facility to them that we can. We will suspend the case while the mediation goes on elsewhere. The only thing they must be aware of is that obviously if they decide to mediate outside of the EUIPO, they're going to have to pay for it. And sometimes that might be quite a considerable amount of money that they need to pay for, depending on the amount that's actually at stake in the dispute. Sven already mentioned in the question and answers session about co-mediation, and I mean, it's just important to say that in the EU, the European Union, there are actually 24 official languages. So that's an awful lot of languages. And it can mean that sometimes, or it will almost invariably mean that the parties that come to us actually speak different languages as a mother tongue. So they may well use English for the joint sessions to speak to each other. But in the private sessions, and we'll go on in a little while about how these all work, they will probably feel more comfortable talking about things in their own language. So this is where it's very useful to have mediators that speak different languages and the mother tongue of the parties, and are able to. All our mediators are obviously able to operate in English as well. Sometimes nationality can be an issue in the selection of mediators. So it can happen that somebody wants a mediator who speaks French, but they don't want a French national being the mediator because one of the parties is French, and therefore they think that mediator will be naturally biased towards somebody of his or her own nationality. So sometimes we have to take somebody who speaks the language, but it's not their mother tongue, and they're not a national of the country where one of the parties comes from. Yes, and as I've said, the ADR service, our ADR service, can help in the selection of mediators. So planning for the mediation. So if we've got the mediation initiated, the next thing that we need to do is we as a mediator need to send the parties an email introducing ourselves and just setting down a few ground rules. So we actually have a dedicated email account for mediation. That again is a confidentiality consideration so that it doesn't get mixed up with our ordinary office emails. It's totally separate from our ordinary business. And in this letter of introduction, we would, of course, thank the parties for having appointed us as mediator. We would ask them to let us know where they want the mediation to be to take place. Normally, that would be in Alicante in Spain. It could be in our Brussels office. Exceptionally, it could be in the country of the parties. If both of them are from one particular country, then that could be done as well. And now, obviously, for the moment, everything is online, so this issue doesn't arise. And it's always possible to say, well, actually, we don't want to physically meet. We just want to do everything online. Obviously, there are cost advantages there. Now, we would also ask for the dates on which, a range of dates on which the mediation could take place. And basically, this is about matching diaries. So the mediator has to look at his diary, then he looks at each of the dates of each of the parties, and then we try and agree on a date. And as Sven mentioned before, it's usually one day, but it can be more. And with online mediation, I mean, obviously we are more flexible about this than with a physical meeting. And then we would ask to know who would be attending the mediation, because obviously all those people have to sign the confidentiality agreement and be bound by the rules. And we would also insist, as Sven mentioned, that the business decision taker was present, or at least was available. You know, as I mentioned before, if it's a big CEO of a multinational company, then maybe he has to be reached by video conference or by a phone call, but he has to be available in order to get give authority for a decision, a settlement decision to be signed and to be agreed to. So the people at the table, they have to have some authority to bind the company. On that subject, obviously, it's quite difficult to know what degree of authority parties have, because they may have often an authority to bind their company, but only up to a certain amount of money. And I mean, realistically, it's very difficult to know that information, because that's part of the negotiating tactics. And even if the parties think that you're a very nice fellow and they've got confidence in you, they're highly unlikely to reveal what their upper limit is. You just have to bear in mind that there probably is an upper limit. But then again, you may say, well, if you say, well, we don't know what your upper limit is, but if ever that is reached, would it be possible to have your CEO on the line so that you can have authority to exceed that amount if we need to go slightly above it, or if that looks like the way of reaching a settlement. Then we would ask them to return. We would attach the mediation agreement, which is, basically where all these details about attendees and the venue would be contained. We would ask them to fill that in and return it to us signed. And we would importantly ask them to provide us with a summary of the case of no more than 6 pages. They can put annexes into that, but we need to know what's important to them. Continuing on with this, we would then, after we had sent that letter, call the parties individually. And again, it would actually be calling the representatives in the first instance. And we would just follow up on a few points on the introduction, and we would clarify or respond to any queries that the representative might have. I mean, typically representatives will often say, "Oh, I've never done a mediation before, so please guide me. I need some information," and then they will ask you a few questions about how it would be done. Like, for instance, somebody asked me the other day, do you think what would you say about online mediation versus physical presence mediation? Should we wait until all this COVID situation is over, or should we go ahead with online mediation? So that they will ask these sorts of things. They will also, it will be necessary for us to explain briefly how the mediation process will take place, what will happen on the day, and how we will try and conduct it. This is about the process, of course. And then if we've already received a case summary, then we would dig in a bit to that case summary, asking further questions and more background. We would ask typically about the history of any previous negotiations. What were the offers made? Why wasn't it successful? What do the parties think could have been done to have made it successful, for example? Now, obviously, part of the problem here is we're talking to representatives, and at this stage, and the representative may not have been involved in the negotiations. That may have been done directly by the business people in the company. When we would normally also ask, and this is the final point, to speak to the business client, because there are just some things that the lawyer doesn't know on the business side. So it's important that we get to speak to somebody from the business, and it's also important to already get the lawyer and the parties thinking about ideas for settlement, so that they start being a bit creative, and we make it clear that we're not there just to come up with solutions for them. As Sven said before, the best solutions, the most sustainable and durable ones, will be by the parties themselves. Now, okay, it may be necessary, we're still at the pre-mediation, we haven't yet had the mediation conference, as we call it. We're still at the stage of preliminaries. It may be necessary to have several calls or video conference calls with the representatives and the clients to get all this information. And basically, at this stage, it's important that the mediator tries to make sure that we've got the right people around the table, that we're going to have the right people around the table. So what we don't want is that the CEO says, well, I'm very, very busy, but I can spare my trainee to come, or my intern, I'll send him. Obviously, that's really not going to be satisfactory, because that person's not going to have any authority to decide anything. And it could be insulting if the CEO of the other company has made the effort to come, and then he's expecting to see his or her counterpart, not to see the office boy that makes the coffee, for example. Now, we need to establish as a mediator already some sort of rapport with the parties, with the lawyers, while we're making these preliminary investigations. It's all about getting a level of trust from them, and getting them to understand that we're genuinely interested in trying to help them and their clients solve their problem. And we're doing our utmost, we're working diligently to try and find a solution with them. So the mediator drives the process, and we have to be efficient, we have to be a professional, and of course, at all times, we have to be impartial, as Sven's explained in the last webinar. And as Sven also explained, we're trying to shift focus from past grievances, which tend to be all the legal issues, and moving to the present, and then looking forward to possible solutions about how this problem might be, how these issues might be solved, and how this may be done in a durable and sustainable way. Moving the parties from the past to the future. And all this process can be begun even at the pre-mediation stage, especially where we're video conferencing with them. And, in this sense, in some ways, we're already coaching the parties how to get the best out of mediation. I mentioned in the questions and answers session of the last part that the role of the opening statements is not to plead to the bench, that it's not the idea that the lawyer's getting up in front of the court and trying to present his client's case in the best light so that the judge is convinced that his client should win the case. No, that's not what it's about. It's actually about trying to convince the other party that what the proposals and the conduct and everything they're doing is fair and reasonable, and that there's room for a negotiated settlement in this particular case. So it's important for the parties to be coached, and the lawyers to be coached on how to get the best out of the mediation process so that actually everybody wins. And as Sven said yesterday, it's about enlarging the pie, if that's possible. Not always possible, but can be. Okay, so we've now got to the mediation day, which could either be a virtual session or it could be physical. In the little picture, of course, it's the classic physical session. And we would have an initial joint session with the parties. We would then go into individual caucuses or private sessions with each party individually. And it would be important to spend an equal amount of time with each party so that the other party doesn't think that we're favouring the other one over him. And we could intersperse these individual sessions with joint sessions if that were appropriate. And that would probably be when we got to the bargaining phase that this would most likely happen. And then, as Sven mentioned, we would try and draft a heads of agreement or some sort of memorandum of understanding so that some roadmap was left in writing, and then there would be the conclusions where the mediator went with the parties on what the next steps would be. Typically the lawyers will go off and draft a settlement agreement by such and such a date, and there'll be an actual clear roadmap of how things are to progress. So now I'm going to go a bit in more detail in these 5 points. The initial joint session, well, this is about the mediator explaining his role and setting the ground rules for the day. As I've already said, the parties make their opening statements, and it's important that the other party doesn't interrupt the party that's making the statements. Occasionally, parties, there can be quite high emotions in, like bad faith cases, or where the parties have had a previous working relationship with each other which has broken down. What you don't want to avoid is one of the parties interrupting the other while he's making his opening statement. You would simply say, please don't interrupt. You will have a chance to respond, and we can deal with any questions you've got after both of you have made your statements. Then that would indeed be what would happen. There would be comments and discussion on the basis of these opening statements. And typically we would progress to draw up a list of issues, a sort of agenda, if you like, for the day about things that need to be dealt with by the parties. And these could be prioritized. There could be some prioritization of these issues made with the parties. Now, once we've done that, we would then actually go into the caucuses, the private meetings. So this is one-to-one meetings. So it would be the mediator talking to each of the parties individually. And of course, actually, it's usually a team. It's the party the end client, the company, plus his lawyer, and maybe even either a financial officer or legal officer from the company. Of course, it can be, for smaller parties, it could be just the individual and his lawyer. And in this exploration phase that we then go into, we're trying to fact find. So although we've tried to do this a bit in advance in the pre-mediation, there are always going to be things that we need more information on, and we will then dig into all the facts that underlie all the issues that have been identified. And as Sven mentioned, it's trying to move parties away, or they will start with positional points of view, and we need to get behind those positions and understand what are the needs and interests that drive those positions. And we will also try and find, we have to maybe start with legal issues, because typically, as we mentioned before, we want the lawyers on our side. So we can't say to the lawyers, straight out, well, it's all very interesting about your legal issues, but actually we're not interested in them at all. We want to know about the business that's behind them. We have to start off with the legal matters and then try and gradually get behind what are the legal issues. We will come back to the legal issues when we do reality testing, because we need to consider best alternatives to negotiated agreement, which will obviously be litigation. I'll deal with this in a minute. We're again moving people towards the future, getting them out of this historical entrenchment. That's important. Then after we've done the exploration phase with both of the parties, we will move on to hopefully the parties actually starting to formulate offers. And we would then go into bargaining and negotiation. Now, what happens if we get an offer that's totally unrealistic, or what we call an insult offer? Sven mentioned this briefly when he was talking about the $500,000 or euros offer for a small company's trademark. The party shouldn't rush into an offer. They should really be able to explain why this offer is being made. And sometimes we use this Gestalt Theory technique, which is actually trying to get basically it's about trying to get the party to consider how the other party would react to the offer that he or she is making. And it can even be done by actually this changing chair technique. So you'd say to the party, well, come and sit in this other chair and answer from the point of view of the other party to your offer. What would you think a conversation from the other party would sound like regarding your offer? And that's just to get people to think about, to empathize with the other party. It doesn't mean to say they give up and say, oh, well, we can't be right. It just gets them thinking, look, I've got to sell this idea as being fair and reasonable. Does it sound fair and reasonable to me if I put myself in the shoes of the other party? And again, on the reality testing, it's important to use these Batner and Wapner techniques. That's the best alternative to a negotiated agreement. That means, what would happen if you went to court? Okay, give me a realistic evaluation of the costs of going to court. And there again, we're going to need the lawyers. And normally we would actually ask this to be done in the pre-mediation phase, because experience shows that lawyers are usually quite reluctant to be totally transparent about all the costs that are going to be involved, or they don't really know how to do it. So you have to give time for everybody to give realistic evaluations, and you may need to challenge those evaluations. Saying again, like Sven said, that may be where you bring in the expert determination. You suggest expert determination, an expert opinion to be given on this, on the chances of success. And sometimes you may need to separate the lawyer from the party to say, well, look, come on, you're not being realistic here. We know that the trademark is a very weak mark. It has a lot of problems. It's really quite unlikely that you're going to win outright. Maybe your chances of success are a lot less than what you're saying. I mean, obviously, this has to be done with great skill and diplomacy, not to insult the lawyer. And certainly, as Sven said, never do it in front of the client. And then the WATNA, which is the worst alternative to negotiated settlement, that's a similar technique. And then the ZOPLA is the zone of possible agreement. So then when an offer is formulated, you as a mediator may need to reformulate some things. For example, if part of the settlement involves an apology being made, it may be that in some cultures, I mean, it's very cliched to say, but typically people say, well, in Chinese culture, for example, asking for an apology or giving an apology is seen as a loss of face and is, it will be very difficult to get that. So you as a mediator may not actually ask for the apology. You may say, well, look, it would be really helpful if you were able to explain why you did something, why you did something or didn't do something, and what were the drivers behind your actions, so that the other party completely understands why you did what you did or why you didn't do something, and it will just help them understand. So you may not get the apology, but you'll get something that will be hopefully satisfactory to the other parties. So for this, you may actually not use the word apology with one of the parties. You may choose to use different vocabulary to get around these sorts of things. And you will be, as a mediator, shuttling to and fro from the parties and essentially using facilitative mediation techniques. That's where you're getting the parties to come up with their own solutions. You're facilitating a safe environment in which they can do this by saying, look, anything you tell me in these individual caucuses is confidential unless you authorize me otherwise. And the objective here is actually to get authorization. It's to find out what are the possible issues that need to be explained, and then you need to convey those with the appropriate permission from the party that's giving you the information. You need to then convey that information to the other party in such a way that confidentiality is actually waived for certain information. But at the outset, you create this safe environment by saying everything you say to me will be treated as confidential unless you authorize me otherwise. So you then try to find out what are the things that can be authorized otherwise. And this is how you get the momentum going for the dynamic of the mediation process. Well, as I mentioned, you may intersperse these private sessions with joint sessions, and this would particularly be where bargaining started to get to an advanced stage. It may also, if there were an apology that needed to be made, then obviously you would need to, that's something you could deal with fairly quickly. I mean, normally we would also, this is something important to mention, we would try and deal with things where there was a quick win possibility first. So if one of the parties felt that he had been insulted, for example, by the other party, we would try and deal with that at the outset by getting an apology from the other party or some sort of acknowledgement. And the idea behind this is that this serves as a dynamic of once you've gained ground on one aspect, then this creates a dynamic for moving other issues forward. Again, joint sessions would be useful if you were looking at ways of making the pie bigger. For example, if an idea of a license came up, then you may need to get the parties together to start discussing what would this license look like? What would a joint venture look like? It could also be joint problem solving. Again, in mediation that Sven and I did, as he said, we've done quite a few together. A tax issue came up late in the evening, and we needed everybody to get together about okay, if compensation is paid by one party to the other in a cross-border situation, who pays the tax? And so we needed everybody to put their heads together to try and solve that. Now, again, it could be issues of competition law. Perhaps what's being proposed is contrary to antitrust rules. Again, the lawyers then need to get together and try and solve these things. And so legal issues, it's quite common that we would actually need the lawyers together to try and find a creative way of getting around any legal problems that crop up in relation to a proposed solution. And then, as we've already mentioned, sometimes you need to separate the problem from the people. So you may need to take the lawyers aside and have a word with them separately. Drafting heads of agreement. Well, I think we've already dealt with that in some detail, so I won't go through that, except just to say, obviously, sometimes the mediator does get involved in our mediations in drafting, but always with the assistance of the parties and their lawyers. So it's really a team effort in getting down the heads of agreement or the memorandum of understanding. It's important that the parties don't leave the mediation without what's been decided being put down in writing that for the next steps. Well, conclusions on the next steps. I think I've already said that the lawyers will deal with the settlement agreement. We've discussed a lot about enforcement of applicable law and forum. There's always the Med-ARB possibility, so you could have a clause that foresees that if there's a breach of the settlement agreement, then there's the possibility of an arbitration or a mediation followed by an arbitration. And the mediator would be available, we would keep ourselves available to assist the lawyers typically or the parties in any problems that crop up with drafting the settlement agreement. The mediator destroys all of his notes, and then we would remind the parties that they need to close the proceedings before us and before any other authorities or courts anywhere in the world where they're ongoing proceedings before the parties when everything's done. Well, that's all I've got to say on this. I'm looking forward to your questions. Thank you.
Thank you very much for that, Gordon. Let me share my screen for some of the questions. So I think Sven is also joining us for the Q&A. But
Here I am.
Hi. Okay, to proceed with the first question, is there any legal rule regarding the time limitation for completing the mediation process with the boards of appeal?
Okay, what I would say is that normally we try and do the mediation within 1 day, but as Sven mentioned, sometimes it's not possible to do the actual mediation conference I'm talking about within 1 day if it's a particularly difficult problem. We don't have a requirement in our rules limiting us to 1 day, particularly because we want to retain some flexibility in giving the best possible opportunity to the parties to resolve their dispute. So basically, we don't have a legal rule as such, but obviously it's in everybody's interest that we try and resolve the matter as quickly as possible. So we go according to the timetable that the parties want, and that's actually what the mediator tries to establish in the pre-mediation phase. We try and establish a timetable with the parties about when the mediation day is going to take place. And obviously, if then after we sign hopefully the heads of agreement, there's the lawyers then need extra time to draft a settlement agreement. We don't impose any time limit on that. That's just a matter for the parties to decide. But sometimes it does take a couple of months for them to hammer out a settlement agreement. But once we found that once they've signed these heads of agreement, they've got a clear roadmap. They know where they're going. There may be a few little hiccups on the way, but they get there in the end. Ben, is there anything you want to add to that?
Yeah, maybe just a little in addition, if you allow me, Gordon. I think this timing is an important issue, and the mediator should never, let's say, kind of stress the parties. I mean, if there is if you meet, even if they have come from far away, and there's no way moving forward, it can have different reasons. It's actually wise to stop the mediation and ask the parties, I think we have to take a break now. And the party, or either the mediator or even the party, can say, look, for the time being, we don't want to continue. But what is important then is a follow-up. I mean, even if the party said, look, we don't really see any room for settlement, or we don't like this, I mean, give it another last chance. This is what Gordon and I have done in many, many mediations where the parties actually said, look, there's no way, there's no agreement, no settlement possible. So they go out of the mediation room. And then after 1 week, 10 days, we contact the parties again and try to see and to explore if maybe after these 10 days, there was a kind of thinking process done by them and that they can actually go back to the table. So this is very important, not give up and continue at least one time to contact the parties again and see if there is room for a settlement. Thank you.
Yeah, next question.
Okay. For the next question, what happens if the parties dismiss the current mediator or the mediator has to step down for whatever reason? Would this process need to restart, or does the new mediator just take over from where it was left off?
Okay, well, the first point I have to say is, fortunately, this situation has never arisen with us. But were it to arise, we would, again, because of the flexibility of our process, it would be for the parties to decide what they wanted to do. We would obviously offer another mediator to step in. Obviously, if a new mediator steps in, I think that that mediator has to familiarize himself or herself with the process. But it wouldn't make much sense to insist on a new summary of the case and things like that. Obviously, the new mediator would inherit all the papers. Because if that situation arose, that then the outgoing mediator wouldn't destroy all the paperwork, and the new mediator would take over. But at the end of the day, it's totally it's at the will of the parties. So if the parties say, well, we're dissatisfied with what we've seen, we want to end it here, then obviously we would have to respect that, although we would do our utmost to try and persuade them that we will accommodate their wishes in any way that we can. And again, I repeat, this has never happened in practice. Sven, anything to add?
Yes, I would just maybe, and I'm not so sure, Gordon, if you allow me, because if the mediator needs to step down, I mean, first then you need to explore why the new mediator, and you need also to check if the new mediator is allowed to have access to all these documents, and I think you need to review a little bit the process, because the mediator, the new one, needs to also understand the underlying issues. If you have papers it's written down, okay, then you can probably use it, but I think this is then up to the mediator to see which information he or she has inherited and to see what he can use, and if it's necessary to actually, let's say, review a little bit the process. But this is a very uncommon situation, and usually we don't have that, as Gordon correctly said.
Okay, then we proceed to the next question. If the disputes involve parties from different countries and legal jurisdictions, how will the applicable law or jurisdiction be determined? Again, this is the same question as yesterday on the question of choice of law. Is it appropriate for the mediator to make a proposal, or should this be left solely to the agreement of the parties?
Okay, well, the first point, first off, is that the mediation process is not governed by any system of law. It's not an arbitration, right? So we don't have an applicable law to our mediation. We of course have mediation rules, our own mediation rules that we apply, but they're not mediation rules from any one system of law. I mean, naturally, as I explained yesterday, our rules are inspired by the EU Mediation Directive, but I don't think they're saying anything radically different to any other mediation system anywhere else in the world. Where the choice of law is important is in the settlement agreement, because obviously that has issues as to enforceability, and there may also be a forum, a selection of the appropriate forum. So you could also have a clause that provided that not only would French law apply, but the courts of France would be competent in the determination of any dispute arising on the contract, the settlement agreement. Because after all, the settlement agreement is actually just a contract, so it becomes a contractual dispute. Would the EUIPO mediator be involved in deciding which law was appropriate and which court was appropriate, which choice was appropriate? The answer is no, because that's purely a matter for the parties, and it would be absolutely inappropriate for the EUIPO mediator to intervene in any way. The parties are absolutely free to negotiate the choice of law and forum and resolution means in the event of a future breach that they see as being appropriate. Ben, do you have anything to add?
No, Gordon, you have answered the question perfectly. Next one.
Okay, next one is, in the EUIPO, before making any decision, may the parties request the boards of appeal for an oral hearing? If yes, what is the difference between that oral hearing and the mediation proceedings?
Okay, an oral hearing is completely different to mediation. So an oral, in our ordinary work at the boards of appeal, when we are deciding cases as a panel of 3 judges, we have the option of calling the parties for an oral hearing. So we can, in normal circumstances, we actually get submissions made in writing, and that we have a written file, and we decide on the basis of papers that are submitted to us. In some circumstances, for example, in bad faith, in Svensborg last year, there was an oral hearing, and the parties were called to give explanations on factual matters that had a bearing on legal issues. And in those circumstances, then the oral hearing would be the basis of the decision that was then taken by the board. But this is decision-making work. It's nothing to do with mediation. Mediation, I hope I've managed to explain what the process is. That's a completely different process to oral hearings. The only thing that I would say where there could be a link between the two is that if the parties come to Alicante for an oral hearing, it would be possible for the panel of decision makers in the boards of appeal to call the parties aside and say, have you tried to solve this case amicably, and don't you think it might be a good idea, and try and persuade them, and then it could lead to a mediation. But then again, it would need the agreement of the parties, and normally once parties are embarked on oral proceedings, they're very far down the road of the traditional litigation process. Sven, would you like to add something?
No, I think not necessary. You have answered everything.
Okay. If you'd agree, we have a few more questions that we can go
ahead.
We're a bit out of time, but if our participants can continue to participate and we can answer more questions. The fifth one is, will there be any point where the mediator decides that there is no possible resolution, and what happens after that in the EUIPO?
Okay, that's a very good question. Basically, there can be situations where the mediator sees that there's absolutely no point continuing with the mediation. As Sven said yesterday, it's not just about taking. The process is not just about taking, it's also giving. You need to give in order to receive. If somebody is just intent on taking and has no intention to give whatsoever, and they're not acting in good faith, then it's going to be very difficult to make progress with the mediation. If you've got a very hostile lawyer, for example, it does happen that you have lawyers that are antagonistic to the whole mediation and ADR process. They don't believe in it. They see it as a threat to their bread and butter, which is court work, and they want to disrupt rather than to assist. It's exceptional, but it could happen. I mean, obviously, you would try and separate the problem from the people. Like we said, take the lawyers aside and have a word with them. But if all these techniques failed, then there may come a point where you see that it's just wasting everybody's time to continue. I have to say that I personally try absolutely everything to keep the parties in the room and keep the process going. But there may be a situation, it hasn't happened to me yet, but I know there can be situations where you have to call it a day because to continue is just wasting everybody's time. Okay, Sven, would you like to come in?
I mean, what you have said, Gordon, I think it's very important not to give up too early, because you will come definitely. If you have a mediation which goes very smoothly and after 2 hours you have an agreement, with all my due respect, I think then the crucial issue were not tackled. It's impossible. you will come, if you do a good mediation, you will come at least 3-4 times at a very serious deadlock and very difficult situations where one of the parties or maybe even both want to run out of the mediation. That's then, if this happens, then you should be very happy as a mediator, because then you know you've got to the core issue of this dispute. And then you need to use all your negotiation skills and mediator skills, all the techniques you have, and then you have to explore. You have to use open questions and to find out the underlying issues. So what I want to say, you will definitely, again, come to the situation where the people say, no, there's no way, I'm not interested, or no, I want to stop here. And lawyers or parties might be even rude and whatever. This is exactly the good moment of the mediation, because then you need to find out what the underlying positions and interests are and dig further into the facts and interest. And so don't give up early, go further and take this as a chance, because it is a sign that you are on the right track in the mediation.
Yeah. Next question.
Next question. If you have any, can you share experiences on mediating parties that have already agreed on major issues except for one word, and it has been pending for a long time already? If you have experienced this, what did you do to finally convince the parties to submit to their compromise agreement?
I don't have any mediation experience of only one word that separated the parties. However, in conciliation, there can be situations where, usually not one word, but where there are a few words that separate them. Usually it's on a limitation of goods and services. It's finding the right limitation. And it has to be a limitation that not only satisfies both parties, but which is legally acceptable. So, for example, you can't extend the list of goods and services in any way. You can only restrict it. You can only limit it. You can reword it, provided it doesn't extend. But you can never extend in any way. So there have been situations where we've argued, or where the parties have been arguing about wording, and where we've managed to find. I think there was something about it was the swimwear and wearing, whether they could make any provisions about who the swimwear was intended for, and we managed to get round it by using the word designed instead of intended. So yeah, but it's very exceptional. That's the only one I can think of. Sven, do you have any experiences of this?
Yes, I mean, I understand the question a bit more in the way, if you don't find, let's say, a solution for all the pending issues. Yeah, I mean, it's what Gordon has said is one possibility, but I don't know. But I can just, if it's also meant to let you only find, let's say, a partial agreement in the mediation, if that is meant with this question, I mean, yes, I mean, again, it depends on the parties where they want to settle. They can only settle half of it, or 10%, or 150% if they want. So that's no problem to find partial solutions and to not conclude an amicable settlement for all pending issues.
Yeah.
Okay. Next one. Oh, sorry.
I was just going to say on that subject. I mean, I've actually just yesterday I've been involved in as a reporting mediator, a case where there's a number of ongoing disputes, and it's a ministry. Well, it's a government entity with various ministries that are responsible for different cases. So it's quite on one side. So it's quite complicated, and the other party is actually just a supermarket, and the supermarket is a very big supermarket, but they want everything to be rolled into one mediation process. However, yesterday the other party, after 2 months of consulting with their client, just wrote a very short email saying that actually one of the trademarks they don't want to be included in the mediation. Now what I've done is that's fine, but it's actually going to be quite difficult to sell that idea to the supermarket because they specifically wanted everything. But what I've asked from the representatives of the government entity is explanations about why they want to separate that, because I need to be able to explain clearly. It's about being transparent and clear why that position has been taken. What's the interest behind it? Not just saying they don't want this, full stop, because that's likely to be antagonistic. So just about, I think transparency is key here. Thanks. Next question.
Okay, we have time, I think, for 2 more questions about the fees. Is this something that you can share with us, or maybe they can check at the EUIPO website for the Boards of Appeal?
Well, I mentioned that there is no separate fee for mediation. So mediation itself is not subject to a fee, to a separate fee at the EUIPO. However, it is subject to the appeal fee. So when you appeal a case to the Boards of Appeal at the EUIPO, you have the option of either we take a decision in the ordinary way as a panel of 3, then it could go from us to the court in the EU court if it's appealed, further appealed, or you can opt for mediation. So the mediation fee is €720 for trademark cases and €800 for design cases. But there's no separate fee for mediation as such. If you wish to for us to take the mediation in Brussels, we have an office in Brussels, then you need to pay a small administrative fee of €750, usually borne by both parties, for to just cover our travel and accommodation costs of going to Brussels. Sven, do you have anything to add to that?
No, your answer was crystal clear.
Okay, so now we go to the last question. At any stage, can a party request for a change of the mediator?
Okay, well, you're very keen on changing our mediators. I mean, yes, they could. I mean, with the obviously you need the agreement of the other party. But again, this has never happened. We've never had this situation, and we've been doing this now since 2012. But theoretically, the mediator could be changed. But obviously, because the whole mediation process relies on the agreement of both parties, you need the agreement of both parties to change the mediator. Sven, do you have anything to add to this?
No.
Okay, then next question, please.
I think with that, we can end the Q&A for this session. But I would just
Sorry. We actually had a couple of questions. There's maybe one I could deal with quickly from yesterday's session.
Go ahead, please.
So somebody asked for more examples of hybrids. And basically, the classic example would be where we have a non-binding adjudication, which is rather like an arbitration, where legal issues are clarified at the outset, but in a non-binding way, either by non-binding adjudication or by an expert determination. And then we go into the mediation. So that would be a hybrid between adjudication, expert determination, or arbitration, however you like to call it, and and mediation. Or, of course, that could happen when we got to the reality testing phase of proceeding. And somebody asked also whether conciliation is equally as binding as compared with mediation. I mean, essentially, yes, because where you have a conciliation, you're usually either going to make a restriction to the list of goods or services, or you're going to draw up a coexistence agreement whereby you delimit territories in which the respective parties exploit their trademarks. So it's no less binding than a mediation.
Thank you very much, Gordon and Sven.
Thank you.
Thank you. Bye-bye.
Bye.